हेलो दोस्तों, आप सबको मेरा प्रणाम। हाउ आर यू ऑल ऑफ यू? हाउ इज योर प्रिपरेशन गोइंग ऑन? So welcome to Sushruta batch. Say hi, hello in chat box. Yes, Ipshita, Roy, Umesh Saini, Srinivas, Ramanujan. Okay. Sanjana, Chandan D. Okay. So how is your preparation going on? Snehajit Chaudhary, Arshita, how is your preparation? How is your third year? How is your third year journey? Okay, Rajat from Karnataka, fine. Royal Medico, Madhusudan, Sanjana, Lokesh. Yes. Okay, Mohammad Ansari. Chalo. Ruday, DS. Okay. So in last class we discussed about orientation of forensic medicine, like what is forensic medicine and types of inquest and all. So in this session, that is basically legal procedure 2. So before starting the actual topic, so let's start with some new initiative, Booth Bungalow series. Booth Bungalow series. So I consider autopsy room, that is we call it as Shava Pariksha room, as Booth Bungalow, because there will be 20-30 dead bodies all the time in freezer compartment in major hospitals. So autopsy room, that is Shava Pariksha room. So basically that is Booth Bungalow. So let's start one very interesting case. So this is a case. So all of you concentrate. A 40-year-old male found dead in unnatural condition. So a driver था, basically lorry driver था. So actually he was waiting near a garage. So suddenly in garage there was tire blast. So what you can see here, tire blast. Okay, and he died. He found dead because of the tire blast. He was waiting near the garage. So probably some work related to lorry or some tire basically. Then during autopsy examination, that is Shava Pariksha, so what I found, so we found this is ear, tympanic membrane rupture and bleeding from the ear. And the lung, that is showing what you can see here, contusion. Contusion is there. So it looks like a flashed lung with multiple findings. Then heart look normal, liver look normal, intestine there were rupture. So my question is very simple, मौत का कारण क्या है और मौत का तरीका क्या है, and what type of inquest, what type of कानूनी जांच that is needed in this case. स्नेहाजी चौधरी, रुदय, what type of कानूनी जांच, मौत की कारण and मौत की तरीका, manner of death. Can anyone answer? So Snehajit is telling sir heart attack. So but look at the heart. So during autopsy examination, So booth bungalow, shower pariksha, heart completely normal. No heart attack, nothing. But ear that is showing bleeding, tympanic membrane rupture, lung that shows contusion. Yes, come on, try. Ipshita Roy and others. So this is classical case of primary blast injury or air blast injury. So what is the cause of death? So lung injury. Or we can say multi-organ injury like ear canal, the middle ear, the inner ear, and the JIT rupture. Multi-organ injury, especially lung injury, is the cause of death. Lung injury as a result of primary air blast. And the manner is accidental. And the inquest required is police inquest. So very simple it is, very simple. Good. So Sanjana, so many they are answering. So it is a case of air blast injury. So this is about the bungalow series. We'll have some more interesting question in next class. So now we will start legal procedure 2. What are important short essay, important 3 marks questions that can be asked from legal procedure as per CBME curriculum? Okay. So my entire classes basically to prepare you for the university exam, at the same time to prepare you for INA-CET exam, NEET PG both. It is like a hybrid. So not only theory, not only MCQ, it is like a hybrid. And my class notes, it is more than sufficient for your upcoming exams. So there will be around 32 classes from me, forensic medicine, in 32 classes, 32 and plus 8 FARE classes, total 40 classes in a year. I'm going to complete entire forensic medicine, everything that is, everything whatever needed for your exam. So आपको टेंशन लेने का कोई जरूरत नहीं है, ठीक है? Okay. So inquest, very important question. So last week we discussed about inquest. तो आपको याद होगा. So courts of law. What are courts of law? 3 marks question. What is cognizable, non-cognizable offense? Subpoena and summons. And very important, evidence. The evidence can be 3 marks. Perjury 3 marks. And duties of doctor in a witness box. What are duties of doctor in witness box? So that is usually long essay. Okay. Chalo. So let's start now. Courts of law. So I'll go a little slow today because many of the students are beginners. So courts of law, that is judiciary. So as you know, in last class, there are 3 important codes related to our practice: BNS, BNSS and BSA. So what are the codes? So what are the types of court? That is Nyalay. So basically national level, state level, district level and sub-district level. At national level, we have Supreme Court. At state level, we have High Court. District level, that is district means Jilla. At Jilla level, basically district or session court, additional district court and assistant district court. At Taluka level, so basically we have CJM court, Chief Judicial Magistrate, first class magistrate and second class magistrate. So remember, there's only first class magistrate and second class magistrate, no third class magistrate. Okay, so don't write this in your exam. Some student they mention first class, second, third and fourth class. So we have only first and second, not the third. Okay, you're getting my point. And as you know, civil court, criminal court, fast track court, juvenile court, labor court and all. So that is a different classification. So this is the classification you must write. This is basically the courts, basically criminal courts we are talking about. Yes, Srinivas and all, so very attentive. That's great. Now, can anyone answer what is the highest power of Supreme Court? So let's make it interactive. Highest power of Supreme Court. So Supreme Court highest power, it is any sentence. So it can pass any sentence, like it can pass or it can confirm death sentence, life imprisonment, imprisonment, then fine. So imprisonment can be simple imprisonment, rigorous imprisonment, rigorous imprisonment. It all given in fourth section of BSc, fourth section of BSc. So now Sanjana and Snehajit. So can you tell me one indication for death sentence? Death sentence, matlab फांसी लगाना, judicial hanging. What is one indication? So death sentence is the highest sentence given by the court. Okay, next is the life imprisonment. So what is that? Death sentence commonly given in rape and murder. Rape and murder. Like example in Nirbhaya case. So in Nirbhaya case, a female, she was raped by six people in a moving bus. So the accused, they got death sentence. I know, death sentence, Nirbhaya case. Or rape on a female less than 12 years. Less than 12 years. Repeat offender. Repeat offender. Murderer. Okay, murderer. So murder means guilty mind and guilty act. So when it is proved as a murder, when planning is proved, then punishment can be death sentence. Okay, all is our indication. Good. So that's great. Fine. Now we have High Court. So High Court, what is the power? Same. Same power. Then we have District Court. What is the power of District Court? Almost same. Same only. See, District Court and Magistrate Court, they are considered as trial court. And this High Court and Supreme Court, they are basically appellate court. Appellate court. So trial court, that is District Court. So what is the power of additional? Same. What is the power of Assistant Session Court? Max 10 years. Max 10 years. So there is no concept of Assistant Session Court in BNS, BSA and BNSS. So this is actually old type of court, Assistant Session Court. So maximum, that is basically 10 years. Then Magistrate Court, that is Taluka level court. So power basically CJM court. I'll write here CJM court. 7 years of imprisonment and unlimited fine. Chief Judicial Magistrate can pass sentence up to 7 years and fine. So all of you write in the chat box, CJM is equal to 7 years plus fine. 7 years plus fine. Then we have First Class Judicial Magistrate, First JM, 3 years and 50K. Second Class JM, 1 year and 10K. So this is very important MCQ, very important Viva question as well. So, okay, good. So that's all. So that's it about the types of court. So whenever question asked 3 marks question, so this is more than sufficient. Nothing much required, nothing more required. Okay. Then we have classification of offense. You know, there are various offenses like murder, खूनी करना, rape, अत्याचार, chot, that is basically injury, assault. So there are various type of offenses: cheating, dowry death, okay, ragging, attempt to murder, causing grievous hurt, acid damage and all. So classification of offenses, basically cognizable, non-cognizable. So cognizable matlab, so the police can arrest the person with the warrant, without the warrant. So he can arrest without the warrant. So cognizable is equal to arrest even without warrant. So warrant normally issued by the court. So warrant is issued by, summons issued by court. So in cognizable offense, the police officer can arrest the accused even without warrant. Can you name one cognizable offense? Can you name one cognizable offense, guys? So like example, murder, rape and all. Good, Sanjana, that's great. Then non-cognizable, so police cannot arrest without warrant. So warrant is needed. Warrant is needed. Like example, simple theft, or we can say simple hurt. Simple hurt. Simple hurt. Bailable. So normally most of the cases, so the accused gets the bail, but in some condition the court can refuse the bail. That is known as non-bailable. So bailable, example again, simple hurt. Non-bailable example is murder. Compoundable. Compoundable means any case in which compromise is possible. Compoundable, compromise is possible. Compromise is possible. Like example, simple hurt, voluntarily causing simple hurt and all, compromise. So even familial cases, family cases, maintenance cases, so they are basically compoundable. Non-compoundable cannot compromise. They cannot compromise. Like example, murder. Like example, dowry death. Like example, attempt to murder. So cannot compromise. Then warrant cases. So any case which is having imprisonment more than 2 years, known as warrant case. Any case which has imprisonment less than 2 years, known as summon case. So warrant means more than 2 years. Summon means less than 2 years. So very simple concept. Okay, so now some examples. Look at this now. Now all of you just let me know. Delhi crime, physiotherapist raped by 6 people in a moving bus. One of the heinous crime in the history. So somewhere in 2013, that time I was working in MAMC New Delhi. Okay, so what type of offense is this? Is it cognizable, bailable, non-bailable, warrant case, summons case, compromise, or non-compoundable case? So Ipshita Rai, I've seen this web series. Simple hurt and all we will discuss in upcoming classes. Time being, simple hurt is something which can heal without any scar formation. Simple hurt. So like example, this is simple hurt. Simple hurt. Simple hurt. Simple. So when it causes fracture, it is grievous hurt. That means gambhir chot. That is basically the grievous hurt. Okay. Try, all of you. Okay. Cognizable, non-bailable, warrant case, compoundable, non-compoundable. Compoundable, compromise होगा और नहीं होगा. हाँ, very good. So it is cognizable, non-bailable, non-compoundable, warrant case. Good. So all are getting my point. Now one more. Have you seen this movie? Very nice movie. Our generation movie. Three Idiots movie. है ना? So what is this basically? What is this? Come on, guys. So again, cognizable, non-cognizable. Warrant, summons. Bailable, non-bailable. Bailable, so he will get bail. So, but not easily. So court can refuse the bail. So he need to go through, hearing. So once hearing is done for 1 month or 2 months, then he might get bail. So bail is the right in any offense. So non-cognizable. Non-cognizable है नहीं, ये cognizable है. Ragging is serious offense. So all of you remember, ragging is there, is a very serious offense. It is a cognizable offense. And in ragging, so the person will get bail only in the court, not in the police station. So we call it as bailable or non-bailable, depending upon the severity, the injury. Then one more thing, it is again actually non-compoundable, serious offense. Ragging is a serious offense. Good. Now look at this very interesting scenario. Very, very interesting scenario. So just to explain you about the type of offense. A boy sending repeated messages. Instagram message, Facebook message, text message, waiting outside the female house, okay, with a clear indication of disinterest. So this girl is not interested. She's totally not interested. And she warned him twice or thrice. So, and he's sending messages. He's a bad boy. He's a bad boy. A very bad boy. Like, he's sending, मेरे सपने की रानी कब आएगी तुम? मेरे सपने की रानी कब आएगी तुम? So he's sending messages every day. Instagram, Facebook, all the platform is doing that. Okay, so my question is, what it is basically? Srinivas, ये क्या हो सकता है? Punishable है, bailable है, non-bailable है, or cognizable, non-cognizable, ये क्या हो सकता है? Yes, very good. So this is basically stalking. So comes under 78 BNS. Stalking. And it is cognizable offense. And it is bailable offense. So first offense, bailable. If it is second attempt, third attempt, then it is non-bailable. So stalking can be bailable or it is non-bailable. If it is once, bailable. If it is twice continuously same offense, then it is non-bailable given. So in the first offense, 3 years of imprisonment. Second offense, 5 years of imprisonment. So this is how you can learn. Okay, good. 78 BNS. That's great. Okay. Now look at this. Some family dispute. Okay. Now very interesting scenario. Now see, a female, okay, and male. We call it as husband and wife. And this husband is having sexual thing with another girl, है ना, or another married woman. or married woman. So we can say married woman. So what is this offense known as? What is this offense known as? And is it punishable? Not punishable. Is there any medical legal significance of that? It's also offense, right? जल्दी बताओ. So this is, what is the name given to that? Any male, married or unmarried, having intercourse with married female. The word important is married female. Then it is adultery. So what is this? Adultery. Adultery, it was punishable. Now it is not punishable. Not punishable. And but adultery is a ground for divorce. It's a ground for divorce. So all of you write adultery is equal to divorce. So all of you write this. So male or female practicing adultery, husband or wife, can apply for divorce and they will definitely get divorce if it is proved in the court of law. So ground for divorce. So आप सबको लिखना चाहिए, ठीक है? लिखो. All of you write. Sanjana, Lokesh, Madhusudan. Foreign affair. Some are telling sir foreign affair. Best word is adultery. Adultery. Good. Okay. That's okay, Snehajit. That's fine. Okay, guys. Have you understood this? Say yes or no. New students, second year, third year students, honeymoon batch students. So third year is known as honeymoon batch. So I'll call it as honeymoon batch. So honeymoon batch students, is it clear? Types of offenses. Ipshita Roy. Okay. Now I have very interesting question, very commonly asked in Viva. Summons. Okay. So he is the witness. So probably common witness. So witness can be common witness, expert witness. So he is a common witness and he is police officer, usually police constable. We call it as court constable. So we forensic expert or expert witness, we normally get hundreds of summons, sometime warrant. So because we are the part of the investigation, part of the judiciary, we are expert witness. So this is basically summon. So what is summon basically? Summon is a legal document. It's a legal document. So it's given by the court. So there will be court signature or the judge signature and the court stamp will be there, date will be there, everything will be there in that. So it's a written document. So nowadays in some states in Madhya Pradesh, so they introduce digital summon. So they can serve summon through the email or through the WhatsApp as well. So that is also legalized in some state, especially Madhya Pradesh. Okay. Chalo. Grievous hurt. Snehajit, that is grievous hurt, breaking teeth. We will have discussion later. This is the second class. So there are so many classes are there, so you can learn. So what is summon or subpoena? So this is also asked. Subpoena. Sub means under, poena means penalty. It's a written typed document. So most of the time it is typed by the court clerk, served by the court. It is served by the court. So court means it can be civil court, So it can be criminal court. Compelling. So compelling means must. Compel matlab must. So compelling. The attendance of witness. Witness. So witness in that sense, it can be common witness. It can be expert witness. Forensic expert, expert witness. I can be common witness also. Doctor can be common witness also. Yes, witness in a court of law to depose evidence, to depose oral evidence or sometimes documentary evidence on a particular date and time, particular date and particular time, and under penalty, under penalty. So this is 100% correct definition. This you need to write in the exam. Okay, under penalty. So this is subpoena. Okay. Next comes to what are types. So there are two types: subpoena ad testificandum, that is to give oral evidence. Like example, postmortem certificate. So in postmortem examination, I said the booth bungalow series. So in postmortem certificate, you must give oral evidence as well as documentary evidence both. So document should be given in the beginning. Later that should be testified by a doctor. That is basically oral testificandum. Ducis tecum, so only in documentary evidence. Only for documentary evidence. No need of any oral evidence. So only if document is submitted, that is okay. Like example, fingerprint report. Like example, FSL report. FSL report. Forensic science laboratory report. Ballistic report. All these are basically ducis tecum to produce documentary evidence. Fails to attend. Can anyone tell me? Let's make it interactive. For example, me doctor, expert, forensic expert. I am not attending court. Despite of receiving so many summons, I am just say, no, I am not attending. So this is my attitude. So what is going to happen to me? So if I refuse the summon, बताओ क्या हो सकता है? Come on guys, come on. Fails to attend without giving any proper reason. See, if I have some emergency work, if I have some emergency in my life, if I'm not well, if connectivity problem is there, so you can take other date. You can request the court, so and so, I'm unable to come to the court on particular day, give me some date. So that option is there with you all the time. But now say example, intentionally neglecting court, then what it is? Civil case, it is fine. Criminal case क्या होगा? Cancellation of license. You see, cancellation of license is not the function of court. So they might arrest you. Okay, they might arrest you. डॉक्टर साहब आ जाओ हमारे साथ. Like that. So they will arrest you. Police will come to your house. They will say, hi sir, how are you? Come with us. We'll go to court. They can arrest you. Okay, so like that. Arrest. So it can be bailable arrest or bailable warrant. Sometimes bailable. You need to go to court and apply for the bail. Or sometimes non-bailable also. Non-bailable warrant, NBW. Okay, so in my experience, so all this happened basically. All this happened, frankly speaking. So when I was working in Delhi, Maulana Azad Medical College, so I think my evidence was there in 30 Hajari court. So when that time I was not there in Delhi, after completing my MD and from MMC, I was staying in Bangalore basically. So because of some summons issue, I couldn't get any summon. But one day, the Honorable Court, they issued a bailable warrant. So the police constable came from Delhi to arrest me basically. Okay, so this is how it is happening. So, okay, Srinivas, you're getting my point. Srinivas. So forensic doctor is in trouble, serious trouble. I know when you fail to attend, you will be in trouble. So all of you, okay? If I explain with my own experience, are you comfortable with that? My experience and my difficulties in forensic medicine, are my all this, is it okay? It should not be, yes. Sanjana and others. Madhusudan, are of you okay? Hmm? Yes, fine. What happened later? Okay, that's interesting. So Snehajit is telling, sir, what happened later? Then what happened? Then usually no, they respect doctors. So and I said, okay, I'll definitely come in return. So everything, that statement was taken. Then the next date, I attended T Sajari Court in Delhi. So okay. So normally, while attending court, they'll give TADA. They'll give flight ticket or second class train ticket expenses they'll provide. But when warrant is issued, from the court, then that option is not there. They will not pay you TADA. So because you are not there when they called, so that is one, I think, way of fine. So that is how it actually goes. Fine. Two summonses. Say example, I got two summonses. So one from the civil court and one from the criminal court. Say example, one from civil court and one from criminal court. What must I do? What must I do? Okay. So you must attend criminal court, right? So always you must attend criminal court. So this is one thing. Second thing, one more option is there. So one from high court, one from session court. Session court. So one from high court, one from session court. Now you let me know which court should I attend. High court. So always higher court. So higher court. Higher than the lower. So rule number one. Then criminal court. Criminal than civil. Rule number two. Rule number three. Serve first. We call it as the one which comes first, are served later. So there are three rules are there. Three rules are there. The first rule, always you must go to higher court than the lower court. Second rule, always criminal court than civil court. Then third rule, that is when both the court of same level, both are Taluka court or both are Jilla court, then you must attend the court from which you got the summons first. Okay, served first in case of, okay. Now say example, I am having two summons, one from civil case, high court. Okay, so one summon from civil court, high court, one summon criminal, session court. So this is very interesting, tricky question. So I got two summons, guys. One from civil court, maybe some civil case, we call it as civil case, high court. One from criminal case, that is session court, that is district court. Okay, आप बताओ अभी क्या करना है? ठीक है, come on guys, come on. This is again important viva question, commonly asked. So many are telling, sir, criminal cases, they have more priority. Okay. So, but remember, the answer is higher court. Rule number one. So, rule number one, what it states, higher court than lower court. So, the answer is higher court first. Then comes is your criminal or civil. Then comes is first come first. So, this is what tricky question that can be asked in your viva. This is my favorite question during forensic viva in university exam. Only few will answer. Okay, so this is okay, guys. Okay, the next comes is conduct money. See, conduct money means money. Okay, money very important. No, vitamin M is very important. So conduct money is the money that is paid in civil cases. Civil cases, not in the criminal cases, all of you. Conduct money, C for conduct money, C for civil cases. So, and one more thing, remember, conduct money is paid by the party who called him. Paid by the party who called him, and usually at the time of summons. And this amount is decided by the court. So conduct money is decided by the court, not by the person, not by the witness. It is decided by the court. Okay? Yes. So this is very, very important concept. Chalo. So once again, I'll repeat. Whenever 3 marks question, 5 marks question, you need to write definition. Sir, definition hai. So it is a written type document issued by the court, like this. You need to write. So there are 2 types are there: testificandum, ducis tecum. Then fails to attend, bailable, non-bailable warrant. 2 summonses, there are 3 rules are there. 1, 2, 3. Conduct money paid in the civil cases, not in the criminal cases. But in criminal cases, you do get TADA. Okay? In criminal cases. TADA. Matlab, traveling expenses. Say example, I said, so in many other cases, I traveled from Bangalore to Delhi, so to attend the Tirthajari court and other courts in Delhi. So in that case, they will pay you traveling expenses, usually a second class train ticket or sometime flight ticket also, and also lodging, boarding, transport, everything they will provide you. Okay. So I remember long back, around 5-6 years back, when I visited Delhi for some evidence. So Honorable Court, they had provided me TAD. Okay. So that's important thing. Traveling expenses. Okay. Hope you understood, guys. Summons, is it okay? Yes or no? Yes or no? Good. Sanjana is telling arrest warrant. Okay, full form. टाडा मतलब क्या है? Yes, clear. टाडा means TA and DA. टाडा, traveling expenses, traveling allowance and daily allowances. टाडा. Okay. Good. Now look at this very interesting image and a newspaper line. See, my way of teaching is to include all recent scenarios as well. So this is a newspaper headline from 2024. Madhya Pradesh leads the way. That is basically digital summon. We discussed already. So digital summon is something updated thing, so which is actually already implemented by the state of Madhya Pradesh. Good. Daily allowances. Okay. Now already I discussed. So this is okay. Next comes is witness. गवाह. हम बोलते हैं ना गवाह. गवाह क्या है ना? So गवाह means that is a person who provides evidence about the fact in the court. About the fact. The fact means truth. Always truth. Nothing but the truth. Always truth, nothing but the truth. Of law under oath. Okay. So definition. There are 3 types of witness: common witness and expert witness. So in general, there are 2 types, but hostile witness is very commonly asked question in your viva. So common witness, basically common man. Usually eyewitness. Okay, like example, eyewitness in case of murder, eyewitness in case of rape. So usually first-hand knowledge applicable to this. First-hand knowledge, like example, seeing by using their eyes, or hearing something by using their hearing mechanism. So first-hand knowledge. So example, eyewitness in case of murder. Expert witness, so they are expert in the field. Like example, MD forensic medicine, MD FMT, or MBBS doctor also expert. They are also expert, basically. They are not common people. So expert witness. Then hostile witness, we call it as U-turn witness. U-turn witness. U-turn witness means, see, hostile witness is a bad witness. We call it as bad witness in simple word. So what actually a hostile witness will do? So he will give some statement in police investigation. So in police investigation, he says, yes, I was there. I am the witness of the crime, something like that. Blah, 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 he will tell during the police investigation. So, but after a few years, when the case enters the court of law, then he will say, sir, Mahaswami, I was not there. Honorable court, I am not there. I was not there in the crime scene. It is all actually, I don't know anything about the case. So hostile witness is a witness, one who changes his statement. One who changes his statement contradictory to the investigation. One who changes his statement contradictory to his previous statement. So that is hostile witness. We call it as U-witness. U-turn witness. Taking U-turn, no? U-turn ले लिया, मतलब hostile witness. Okay? So yes, this is what very commonly asked. So all of you write in the chat box. Hostile is equal to U-turn witness. Write this in chat box. Yes, then it is punishable under various sections of BNS, especially 229 BNS. So if it is proved in the court of law, but it is very difficult to prove in all the cases. Okay, only in some cases you can prove. So hostile witness is equal to U-turn witness. So look at this now. What type of witness here? Look at this magistrate here. Honorable judge is here. And he is basically witness. And he is taking U-turn like this. U-turn. He's telling, no, I was not there in the crime scene. I don't know anything. I don't know anything. I know nothing. So like that it is. Okay, that's okay. That's okay. This is fine. U-turn witness. Chalo. Next comes his evidence. Again, 5 marks question. Evidence. What is evidence? Types of evidence. What is dying declaration? What is the rule of dying declaration? Compos mentis and all. Again, 5 marks question can be 10 marks question. First, what is evidence? So evidence, so proof, basically simple word, we call it as proof. Now, where is the proof? Show me the proof. Send me the WhatsApp screenshot. That is the proof. Send me the PhonePe proof. That is the proof basically. So birth certificate, death certificate, postmortem certificate, eyewitness, everything that is basically evidence basically. है ना? ठीक है. So oral evidence can be, one is oral evidence. So giving oral evidence, like in the witness box we are giving oral evidence, like this oral evidence. When you given oral evidence, so that is oral statement basically. Can anyone tell me which is better? Oral evidence is best or documentary evidence is best? Let's make it interactive, guys. Which is best? Is it oral evidence that is best, or it is documentary evidence which is best? So, jaldi batao. Many are answering documentary. Documentary. So I know. So many. Okay, Mohammed also documentary. All of you are wrong. The best is oral evidence. The best is oral evidence. Why? Because oral evidence can be cross-examined. Cross-examined. So this is the concept you must understand. Oral evidence is always best. Again, oral evidence can be direct evidence. Direct evidence means direct answer. Direct answer. Like example, eyewitness in case of crime, eyewitness in case of rape, eyewitness in case of murder. Indirect Indirect means circumstantial. So let's discuss one case later. Then hearsay. Hearsay means from third party. When he heard something from the third party, मैंने सुना था, मैंने देखा था. मैंने देखा था means basically direct. मैंने सुना है, so that means basically from the third party. I have seen, that means direct evidence. I heard from someone. I heard from someone. Whenever word someone will come, that is basically a third party. So hearsay evidence has no value. No value. So hearsay evidence basically rumors. So rumors, they don't have any value in court of law. Okay, so this is what important. Third party. No, Snehajit, we cannot say like that. So it's basically, so we'll have discussion about that later. So direct, indirect, and hearsay. Now example, one more example here. So very interesting example. I have two characters here. One is our Gabbar Singh, and our Amitabh Bachchan. Okay. जो डर गया, समझो मर गया. So some scenario. Let's see what is the scenario. In a case of alleged case of murder, खूनी का केस था. Amitabh is a character. So Amitabh got killed. So hypothetical hai. So by Gabbar Singh, a bad man Gabbar Singh, at certain place and a particular day and time. Certain place, particular day and time. Garuda, our Garuda, Garuda character in KGF. So he saw Gabbar Singh with a knife. So Garuda actually, so he saw Gabbar Singh was moving with knife. Okay, so like this, a knife. Okay, and on that day, at that place, few minutes before the murder, not actually exactly at the time of murder, few minutes before the murder. So this is what type of evidence? एक होगा direct evidence, indirect evidence or circumstantial evidence, hearsay evidence, hostile witness. जल्दी बताओ. Gabbar Singh and Amitabh. Sholay is the movie, right? Sholay. Very good. This is basically circumstantial evidence. Circumstantial evidence, indirect evidence. Okay. So this interpretation is done by the magistrate, not by any person, by the magistrate. So magistrate has the power. He will give the judgment depending upon circumstantial evidence. Okay, all these WhatsApp messages, Facebook messages, so this mobile network messages, so all these are basically circumstantial evidence. Blood stain, seminal stain, so weapon, the firearm, all these are basically circumstantial evidence. So they will definitely help in giving judgment. So this is indirect evidence, circumstantial evidence. Yes, all of you guys, have you understood this scenario? Is it interesting? Getting my point? Gabbar Singh, my favorite actor, Gabbar Singh. Okay, ठीक है? Say yes or no? Yes, Madhusudan, that's great. Chalo. Next comes the documentary evidence. So documentary evidence can be medical certificate, like example OPD card, or it can be medical certificate by the doctor, fitness certificate, death certificate, MCCD, medical certification of cause of death, MLC reports, wound certificate, dying declaration. So dying declaration usually hearsay evidence, but it also a medical evidence, basically documentary evidence. Dying deposition. So dying deposition not there in India. It is there in US and other countries. So all these are basically documentary evidence. So in general, so oral is best. So because it can be cross-examined. Okay. Okay. That's okay. Now let's have a discussion about dying declaration. Very, very important topic. Okay, dying declaration. Say example here. So here is the case. So here is the case of attempt to murder. Attempt to murder. So he got multiple stab injury. Say example, this patient is in very serious condition. He got multiple stab injury. So he got stab injury over abdomen, piercing his aorta, piercing his major organs. So he's about to die. So now my question is, so this is dying declaration. So I am there in the casualty now. I'm in the casualty. He's going to die. We came to know he's going to die in next few hours or few minutes. So while documenting dying declaration, is it oath required? ओथ का जरूरत है और नहीं है? क्या बताओ? ओथ है ना, हम बोलते हैं शपथ. शपथ की जरूरत है और नहीं? Oath is required or not required? If not required, why? The first thing. Second, cross examination. Cross examination is required, not required? So this is basically dying declaration. We are talking about dying declaration. Dying declaration. So my question, oath is required, not required? I am doctor, so I am examining the patient. So his vitals are stable, his mental status is stable, he's everything normal, he's conscious and oriented. I'll ask him, what is your name, where are you from, what happened and all. He is completely normal. So his composement is completely normal. My question, oath का जरूरत है नहीं है? Okay, very good. Yes, good. Ruday is telling, sir, so always dying person tells the truth. Dying person tells the truth, or nobody wants to die with lies on his tongue. I know. So that is what the belief we have. So that's why, so dying person always tells the truth. So oath is not required. Oath is not required. Cross examination not required. Not required. Now next question. Cross examination, is it required? Okay, that is not required. I said leading questions. Next question comes in leading question. Like, what was the length of the knife that is used? Okay. So what's your name? That is not a leading question. Leading question means any question which has answer in it. So did Ram kill you? Did Ram kill you? Or something like that. So leading question, they are allowed or not allowed? Yes. So leading questions are not allowed. Not allowed. Okay. So dying declaration can be recorded by any person. So by normal citizen, by village head, doctor, police, magistrate, anyone can record dying declaration in presence of one or two witness. But remember, when it is recorded by the magistrate, it has more value. It has more value than any other dying declaration which is signed by some other person. Okay, so these are all very important point. Okay, so in exam you need to write like this. So dying declaration is a written verbal statement. Okay, written verbal statement. What do you mean by verbal statement? Verbal. Is it, say, recording video? Is it legal, illegal? For example, me doctor in the some crime scene, so I don't have any time. I don't have pen, I don't have paper. So nowadays, who will carry paper and pen? It's a digital world. So, but I have mobile, I have very good camera. So can I record a video? Is it a dying declaration? बताओ जल्दी. मधुसूदन, मोहम्मद, आयुष, क्या लगता है आपको? So recording, video recording, is it legal, illegal, or it is allowed by not allowed? Yes, so you can record. So, okay, nowadays you can record video also. You can record video. So that also stands as a dying declaration. Video or sometime audio. Again, this audio video that is cross-examined by the court. So or it is to be certified by forensic laboratory. Okay, so then only it is acceptable in court of law. So statement of person who is dying as a result of some unlawful act. This comes under 26(1) of BSc. So this is very, very important MCQ. Dying declaration comes under 32 Indian Evidence Act previously. Now it is 26(1) BSc. So all of you write the DD is equal to 26(1) BSc or 32 Indian Evidence Act. So please write this in chat box. Then type of evidence. So basically it is oral evidence. Usually oral evidence. Oath not required. Followed in India. Followed in India. Who can record? Any person. Any person. Now next question comes is Viva question in your practicals. Dying declaration is not admissible. Not admissible in court of law in some conditions. So what are two conditions in which it is not admissible? It is not admissible. Yes, come on guys. Let's see who is going to answer. Srinivas is telling, sir, when person survives, very good. When person survives. So when person survives. So point number 1. Point number 2, when he is disoriented. Or we can say no compos mentis. No compos mentis. So in these two conditions, it is not admissible. Okay. So this is very, very important point. Okay. Okay. So this is how you need to write in the exam. In any case of dying declaration, first you stabilize the patient. Stabilize the patient. Then inform the police. Inform police, that is your duty. Record dying declaration. If no time is there, you can record dying declaration. No leading question, no oath. Then after that, you can just read out the lines and you can take the signature. Signature is not possible, you can take thumb impression. Then certify compos mentis, very important. You need to certify compos mentis. That is very, very important. If compos mentis is not there, then it's become very difficult to prove the crime. Compos mentis is very, very important. Orientation, the status of orientation बहुत important है. तो बहुत ही important है, आपको लिखना पड़ेगा. So signature, हस्ताक्षर आपको लेना पड़ेगा. ठीक है? So and also in presence of witness. So this is how you need to write in the exam. Okay, dying declaration, very important, 5 marks question. Then we have one more type. So one more type that is followed in US. That is followed in US. That is known as dying deposition. Dying deposition. So try to understand, dying deposition is not followed in India, but it is one of the best statement. What is dying deposition? Followed in US. Donald Trump nowadays is in news. So dying deposition, Donald Trump. Okay. So fully fledged court procedure. It is like a court procedure. So along the bedside. So when patient is there, so when patient or victim, so along with the doctor there should be accused and accused counsel and the magistrate. So it is recorded by the magistrate all the time. So this is known as dying deposition. So dying deposition is like a fully fledged court procedure. So at the bedside. So all of you write dying deposition is equal to bedside court. Bedside court. That means there will be accused, there will be counsel of the accused, lawyer of the accused, there will be victim, magistrate and the doctor. All 5 members. All 5 members, that is dying deposition. है ना? Okay, so the accused and his lawyer have to be present. Oath has to be administered. Oath has to be administered. Can be cross-examined. Leading question can be asked. If victim survives, it retains value, more value. So it has more value in any procedure. But it is not followed in India. It is followed only in the US and other countries. Okay. So this is about the dying deposition. So I hope you understood this. Then we'll have duties of doctor in witness box. Now guys, come on. So hello guys, are you there? Are you there? Are you tired? Are you tired of classes? Okay. So all of you guys, how is the Josh in forensic class? How is the Josh? So Josh should be very high like your teacher is having. Okay. Come on guys, say hi Josh. Hi Josh sir. All well sir, something like that. Okay. So you can motivate me and you can motivate yourself also. You can keep me awake. You can keep myself awake also. Okay, hi sir, hi. So sir, composement is मतलब mercy. It is the orientation of the person. मतलब confused है or normal है, ये क्या है? मतलब mental status. Okay, mental status is composement is. So Snehaji Chaudhary telling composement is मतलब orientation beta. Orientation to time, place and persons. Like example, what's your name? So my name is Dr. Manjunatha, FMT Guru. So what are you doing? I'm teaching forensic medicine. So I'm oriented. You are also oriented. So like that it is. What is your name? My name is Donald Trump. Where are you? I'm in US. Oriented, disoriented. Say someone asks me some questions. What is your name? I say Donald Trump. Where are you? I'm in US. What are you doing? Something like that. So if I answer like this, orientation or disoriented, composement is present, not present. Snehaji Chaudhary. No. Indirect evidence is not hearsay evidence. Indirect evidence is basically pursued by the person. Circumstantial evidence. He heard something, but he heard by his ear, not by someone. He heard by himself. There was a bomb blast. He heard something there. He heard, not they said. So this difference is there. Snehajit, you are getting my point. Huh? Getting my point, all of you guys? Okay, clear, I think, right? Okay, Mercy, Snehajit Chaudhary. Okay, good. You are enjoying. That's great. Chalo, next. Now, what are the duties of doctor in witness box? So, like example, I am in the witness box like this. Witness box. What are the duties of doctor in witness box? Now, look at this. Our beautiful doctors here. You just tell me. So, is this correct way of attending court? You just tell me, okay? I'm not, worried about male or female or something. But in general, she's wearing jeans, nice t-shirt, apron, and stethoscope, everything. Is this the correct way? Is it apron is must? What do you think? मधुसूदन मोहम्मद देख के बताओ ये क्या है? ये फॉर्मल यूनिफॉर्म चाहिए क्या? और is this okay? Jeans and all, wearing jeans, tight t-shirts, going like this, like an expert witness, going like this, doing gym there like this, है ना? Is it good? Huh? Come on, guys. Come on. So what should be? Apron is must, I think. So Snehajit is telling, sir, apron is must. Okay, that's no, sir. Apron is not must. Uniform is not. Uniform चाहिए. अच्छा, uniform तो पता नहीं कहाँ है मेरा. वो तो I don't have any uniform. I have good dress. So what should I do? Should I wear good dress or shall I buy some uniform in the Amazon? So tomorrow is my court. So should I buy some apron? Should I buy some good uniform? What uniform then it is? So Sutapa, what is your doubt? Well dressed, very good. The first thing is well dressed. So decent dress is important. So apron की जरूरत नहीं है और कोई यूनिफॉर्म की जरूरत नहीं है. आपको फॉर्मल ड्रेस वेयर करना पड़ेगा. वह फॉर्मल ड्रेस. गुड शर्ट, गुड पैंट. Not the other type of dress. Okay. Yes. Apron is not must. Okay. Apron is not must. And stethoscope also not must. So try to understand, there is a judgment from, I think, High Court long back, 10 years back. It is clearly stated that, so for doctors to give evidence, apron is not must. Apron uniform is must in medical practice, basically in medical college, not in the court. You are doctor already. Okay, you are expert. So all of you write, apron is not must. Write in the chat box. Apron is not must. Dekho? Not compulsory. Okay. Sanjana, that's great. Chalo. Now, what are the duties? So I divided duties into before reaching court, after reaching court, and after giving evidence. Before reaching court, in the witness box, and after reaching court. So before reaching court, keep copy of summons. Keep copy of summons. Why? Can anyone tell me why summons is needed? Why summons is needed? Keep copy of summons. Summons की क्या जरूरत है? Second, well prepared with a concerned document. Done. You are a man of science, so be confident. You are a man of science. You are a doctor. Apply leave and permission from HOD. So you just apply leave from the HOD. So and so I'm having court tomorrow. I should apply leave from HOD. If already you are HOD, then you can take leave from dean of the medical college, director of the medical college. Okay, so well dressed and modest. Well dressed होना चाहिए, modest होना चाहिए. ऐसा नहीं है जीन्स पहन लो आराम से जाओ, नहीं ऐसा नहीं है, ठीक है. So why summons is needed? Acha, for attendance. See, I'll tell you why summons is needed. See, the court, very complex court. There are hundreds of courts. In 30,000 and all, there are hundreds of courts. 100 courtroom. First floor, second floor, third floor. In Bangalore and all, around 5-6 floors. We don't know what is going on in some other court or something. So that's why you should have summons. You can directly go to some clerk. You can ask, so where is this court and all. So hall number 108, 109, 110 and all. Summons is needed. Even WhatsApp message is also fine. Okay, just better you keep WhatsApp message. So that's all about the before reaching court. So then comes is your after reaching court in the witness box. In the witness box, आपको क्या करना है? मतलब, so before entering into the witness box, आपको क्या करना है? So first thing, you should go and meet your lawyer. Meet your lawyer. Who is your lawyer? Public prosecutor, government lawyer. PP means government lawyer or government advocate. The better word is advocate. Advocate. Show him summons. You just go, okay, I am Dr. Manjunatha. I am FMD Guru. So and so case. I just came today. Hi, how are you? Like that. Good afternoon, good morning. You can tell. Then go through the case records. Ask him for the case records. So you can take the case records and you can just go through that like this. Okay, and then clarify your doubts. If you have any doubts, you can ask some clarified doubts. So frame some questions likely to be asked by the judge. Sometimes judge can ask question, defense advocate can ask questions. So you can just prepare some answers, question answers in your mind. So this is after reaching court. Okay. Okay, Srinivas is telling, sir, refresh memory, meet the lawyer, use of simple language and attend. Okay, thank you. Good. Meet the lawyer and discuss. Okay, that's fine. Ha, very good, very good. Okay, Sanjana is telling, don't discuss with others. Very good. Don't discuss with others. Don't discuss with anyone. Okay, so you just keep quiet. You just talk to your lawyer. Don't discuss with others. Don't do any unnecessary chat with anyone. Okay, so that is what Sanjana is telling. That's great. Then in the witness box, so what should be your behavior and your statement? So be relaxed. आपको टेंशन लेने का कोई जरूरत नहीं है. आप आराम से like this, you can stand like this. See, like me, है ना? Then calm and polite. Calm. Okay. Polite. Yes, sir. Yes, sir. Yes, madam. Yes, madam. Like that. Honest. Be honest. Honest. Then truthful. Don't be nervous. Don't lose temper. Don't be nervous. Don't lose temper. Very, very important, all of you. Okay. Don't lose nervous and don't lose temper. The defense counsel can ask any question. They can ask 100 of questions, but don't lose temper. In some court, they ask some I can say some unnecessary questions. They asked me. So if you want me, I'll share my experience in one of the court. They asked me, sir, what is your age? They asked me, what is your age? They asked me like that. They asked me my registration number to find out whether I'm doctor or something else. Okay, so then they asked me, married, unmarried. Why? Then I asked, you can say, yes, I'm married. I'm married. I have children. You just say I'm married. Don't say I have children, something like that. So sometimes they'll ask you from which college you are qualified, from which college, private college or government college. Then they can ask something about your college experience. See, doctor, you failed in second MBBS, third MBBS. You never attended any forensic class. Your knowledge is zero in forensic. Like that also they can ask. They can ask 100 of things in the court. Then your answer must be no, 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 like that. Okay, just to irritate you. Okay, that's okay. Then address judge, sir or madam, sir or madam, or sometime your honor. Now my question, all of you guys, which is the better term, sir or madam, or your honor, honorable court? Which is the correct word? Can anyone tell me? Can anyone tell me, guys? Yes, try answering. Your honor. Okay. So yes, in high court and in case of Supreme Court, the better word is your honor. Your honor, honorable judge, honorable court, high court and basically Supreme Court, appellate court. But magistrate court, trial court, session court, you can call sir, madam also, that's fine. So that's okay, that's fine. Then never underestimate medical knowledge of advocate. Never underestimate knowledge of the advocates. Some advocates know they are brilliant. They have a lot of medical knowledge. In my experience, especially in Delhi, in one case of murder, I think, murder or some other case, they asked me lines from K.S. and Reddy, 29th edition. I remember that case. They asked me, sir, you just see here, this is what given in K.S. and Reddy. This is the correct statement given by K.S. and Reddy, and what you have written, that is wrong. Like that, they cross-examined me. So don't underestimate the knowledge of advocates. Be prepared. My lord also okay. That's fine. Then listen to questions carefully, then think before answering. Listen to be a good listener, then you answer. Answer only what is asked. Answer only what is asked. Give direct answer. Like no, yes sir, no sir. Don't give answer like I think cause of death. No, don't do that. Okay. So I hope, I think, almost, I might, or I may think. So don't use that. Don't use that. Okay. Then use simple language. Avoid technical terms. So use simple language, like example, anterior and posterior. Don't use that. Instead of that, inner side, outer side, front of the body, back of the body, the neck, front of the neck, back of the neck, like that. So use common terms, not the medical terms. So medial, lateral, anterior, posterior, and all. Don't use that. Then do not avoid any question. Do not avoid any question. If you don't know, you say don't know, sir. Don't know. Then in my opinion, I imagine, I think, you should avoid all this stuff. In my opinion, wrong. I imagine, wrong. I think, also wrong. Okay. No need to take time to think and all. Okay. So this is about the witness box. So all of you guys have understood this. आपको कुछ समझ में आ रहा है क्या? कुछ समझ में आ रहा है? Or it is above the above the level of spinal cord. Yes, guys. Come on, come on. Okay. Speak distinctly and audibly. Yes, speak distinctly and audibly. Good, good. Yes, sir, clear. Chandana is telling clear, sir. Okay, clear, clear. That's great. So that's great. Easily understandable. Mohammed Zubair is telling, sir, easily understandable. So that's great. Chalo. So iske baad, so now we'll have discussion about, so what is the courtroom procedure for next 5-10 minutes. I am going to complete this. So now you just tell me, there are three important characters here. You need to identify who is this character. Akshay Kumar, my favorite actor, and my favorite judge from LLB, Jolly LLB, and one more here. So can you tell me who are the important characters in any court of law? Jaldi batao. Come on, tell me. Okay. Yes, yes, guys. I'm waiting. Who is that? So in any court, we have a magistrate. So judge, your honor, my lord. So judge. Then we have public prosecutor. PP we call it as. PP, government lawyer, government advocate, government counsel. Then we have defense counsel. So basically, accused, advocate. Okay. Yes, guys. Okay. Good. Defense lawyer, judge, defense lawyer, and licensed prosecutor and evidence. Okay. Now let's see what are the steps. So one by one steps. So always courtroom starts with the oath. So court that starts with the oath. So oath is compulsory, but oath is not needed in case of children less than 12 years. So oath is compulsory. So oath in any language, English, Hindi, Kannada, any language. Okay, oath is compulsory. That is the first step. Second step, examination in chief. By public prosecutor. So just to explain the code that, about the offense, like example, Nirbhaya case. So Nirbhaya case, public prosecutor going to tell, so and so physiotherapist, she was there along with her friend. So she was taken by 6 people in a moving bus, and she was assaulted, and she got multiple injuries, including abrasion, bruise, laceration, and all these are evidences. Okay, eyewitnesses, all these are documentary evidence, all these are dying declaration, everything. So he is going to explain the court about the facts of the case. Okay, so basically examination chief. Then comes his cross examination. So cross examination by the defense lawyer. So defense lawyer now he will ask few questions. He can ask leading questions. He can ask any question. But leading questions are not allowed in examination chief. Leading questions are allowed only in the cross examination. So cross examination, no time limit. Remember this is very commonly asked. For cross examination, it can be 1 hour, it can be 2 hours, it can be 1 day, it can be 2 days also. So this is, try to understand. In one criminal case, in my experience, the cross examine continued for almost 1 month. 1 month. First visit, second visit, third visit, almost 1 month. So a case of murder basically. Okay. So cross examination. So any time. Then comes is your re-examination. Re-examination again by the public prosecutor, just to discuss some doubts so that happened during cross examination. So again, no leading questions are allowed. And lastly, questions by the judge. So question by the judge. So there are basically 5 important steps. The first one is the oath. The second one is the direct examination, examination chief. No time limit, so no leading questions, and basically it's a facts of the case. Then cross examination, no time limit, leading question can be asked. Usually to find out the weak part of the statement of the witness. Then comes the re-examination again by the public prosecutor. Then finally judge. So judge can ask question at any time, even during the cross examination, during examination chief, or at the end also. So judge questions also will be there. Then there will be judge. Then there will be judgment. Judgment. Then after that, appeal. So there can be appeal as well. If the party is not satisfied, then he can appeal to the higher court. Okay. So this is how basically the courtroom procedure that starts and that ends. So this is very important 5 marks question. 5 marks question. So after the class, you just go through these notes. So simplified, everything simplified. So everything ready-made for you. No need to worry anything. Just go through the simplified notes like this: oath, examination chief, cross-examination, re-examination, final arguments. So if you write answer like this, the examiner will be very happy, and you will definitely get good percentage in any exam. Okay? Yes, good, easy to learn. That's great. So this I'll provide you. Just go through this. There are some BNS sections as well, just BSS sections also. So again, facts are there. Just go through that. And the last 10 minutes. So we have some questions. Now before that, I have some questions for you. So you need to identify which is a leading question, which is non-leading question. So identify the type of question. So the first question, all of you, just to go through the first question, second and third and fourth. You just tell me 1, 2, 3, 4 answer. फर्स्ट क्वेश्चन, हत्या में किस हथियार का इस्तेमाल किया गया? इस्तेमाल किया गया. So this is leading question or non-leading question or normal question we say. क्या चाकू की लंबाई 10 सेंटीमीटर थी? 10 सेंटीमीटर थी. लीडिंग क्वेश्चन, नॉन लीडिंग क्वेश्चन. चाकू की लंबाई कितनी थी? कितनी थी? पोस्टमार्टम किसने किया? पोस्टमार्टम किसने किया? So what are these type of question? Just come on guys, come on, try by yourself. पोस्टमार्टम किसने किया? 3 and 4 is leading. अच्छा, 4 is leading. How leading? पोस्टमार्टम किसने किया? पोस्टमार्टम मैंने किया. पोस्टमार्टम डॉक्टर मंजुनाथ ने किया. तो मतलब ये लीडिंग क्वेश्चन नहीं है, नॉन लीडिंग है ना? नॉन है, नॉर्मल क्वेश्चन है. दिस इज नॉर्मल क्वेश्चन. चाकू की लंबाई कितनी थी? नॉर्मल क्वेश्चन. यस, इट कैन बी 10 सेंटीमीटर, 100 सेंटीमीटर. क्या चाकू की लंबाई 10 सेंटीमीटर थी? तो दिस इज बेसिकली लीडिंग क्वेश्चन. लीडिंग क्वेश्चन. हत्या में किस हथियार का इस्तेमाल किया गया? नॉर्मल क्वेश्चन. So only the second one is leading question. So rest all are normal questions. Okay guys, see? So this is how you should learn. Some next level in forensic. Next level. Okay, so you are in level 1. You can just jump to level 2 along with me. Okay. Yes, Mohammed Ayush answering, sir, only 2 is leading. Rest all are basically non-leading questions. That's okay. Good. MCQ test. Last 10 minutes MCQ test. So today MCQ test is there. All of you guys, are you there? Shall we start now? Shall we start? Say yes or no, guys. Say yes. Say yes or no, then we will start. MCQ test. MCQ test. ठीक है? 2 and 3. अच्छा, स्नेहजीत is okay. स्नेहजीत telling sir 2 and 3 में difference क्या है ना? अच्छा, 2 and 3. See, leading question means any question which has answer in it. Leading question is a question which has answer in it. Like example, चाकू की लंबाई कितनी थी? Normal question है. 10 centimeter, 20, normal question है. But look at this. क्या चाकू की लंबाई 10 centimeter थी? Then your answer must be yes or no. Yes or no type of answer. Yes. Yes, 10 centimeter. No, 15 centimeter. No, 20 centimeter. So yes or no type of questions are leading questions. Okay, Snehajit, clear? Snehajit Chaudhary? MCQ test now. Okay, the rule is you need to answer and you need to write one point. Why answer is C, why answer is D, why answer is A, like that. So I'll give you around 20-30 second time. So the first to answer along with the question number. So first you need to write about the question number. Rule number 1. Rule number 2, answer. Rule number 3, why. Why? Okay. This is a rule. This is a rule of forensic medicine MCQ test. Clear? ठीक है? चलो. हाँ. Now look at this and try to answer. A Ram, vegetable vendor, saw a tall person stabbing someone else with a knife. The court asked him about the incident. Ram narrates the whole story in the court, seen by his eyes, perceived by him. This is example for. Okay. What type of? So what type of Gava? What type of Gava? Expert, common, hostile, all the above. So he is basically common man. Look at this Ram. He is basically common man. So his vision normal, hearing normal, everything normal. So he was there near the crime scene. He was the eyewitness. ठीक है? ये किस प्रकार की गवाह है? ठीक है? Okay, Snehajit is first to answer. Okay, Snehajit and others, that's great. Good, Snehajit Chaudhary. Ram is a common man and saw incident in own eyes, so common witness. So good. Snehajit answered. So good answer, common witness. B. So the answer given by Sneha. So given by Sneha. So Mohammad Zubair also telling sir is a simple person. So वो भी ठीक है. Okay. Mercy is telling sir he is basically not the expert. That is also fine. That is also great answer. ठीक है स्नेहा. Okay. True about expert witness, all except is there. A person who is skilled in a particular field has ability to draw conclusion, opinion from observation. Volunteering statement is allowed. First-hand knowledge rule applies here. First-hand knowledge rule applies here. Like observed or perceived by him about the incident. First-hand knowledge. So the forensic evidence, a forensic expert and all, basically we acquired that knowledge by teachers, by experts and all, by books basically. So what is that basically? What is the best answer? Why? Okay, Tota Srinivas, that's great. Srinivas is first. Okay, Madhusudan, fine. Mercy is telling sir to B, C. Sanjana is telling having full knowledge but not first-hand knowledge. D, ठीक है. Sanjana is telling that's fine. He needs to state facts. Okay. Volunteering. Sometime you can give volunteering sometime. So it is also option is there. In some cases you can give some statement. Okay. So that option is there with the expert witness, but not with the common. So but here, so clearly one statement is 100% wrong. So this answer given by Sanjana. Sanjana is telling, sir, D is the answer. Yes. So I said first hand knowledge, perceived by him, observed by him, perceived by his eyes. So that is applicable to common witness, not the expert witness. So D is better answer than your C. Than your C. D is better than C. Okay, so no confusion in that. True about oath, all accept. True about shapat, all accept. Compulsory for a witness before he gives evidence. After taking oath, the person becomes legally bound to speak the truth. A child age less than 16 years, oath is not required. Refusal to take oath, it's a punishable offense. The punishment can be 6 months of imprisonment. Okay. Okay, the first answer given by Muhammad Ansari. So the answer is 16 year. It should be 12 year, I said. The answer is C. So this is about 3. Then 4. True about hostile witness and perjury. So true about hostile witness and perjury. Hostile witness is a person, but perjury is an act committed by him. Option A. Punishable under 229. Punishment can be 7 years of imprisonment. Leading questions are not allowed in examination of chief in case of hostile witness. Best bakery case is an example. It's a bit difficult one. You can try. So A is true. Sutapa is telling, sir, previous question answer. Sutapa here, question number 3. The oath is not required in children. Shapat is not required in children. So Shapat is not required in children of age less than 12 years. More than 12 years, Shapat definitely required. Okay, so this is what given. So it is given 16 years. So everything is correct except this word 16. ये 12 होना चाहिए था, ये 12 मतलब 16 लिखा है बस. ठीक है. Now here best bakery case you can just go through after the class. So you will get some information in Google as well as AI. So here everything is correct. So but here only one word wrong is here is. Okay. Very good. Chandana is telling correctly. So Chandana, good answer. So Chandana is telling, so this is true. So this is also true. So definition comes under 227. Definition 229. The punishment. This is also true. Best bakery case, that is also true. So the best answer is leading questions are allowed. So when witness is hostile witness, U-turn witness, then public prosecutor can ask leading questions. So this is false. So first answer is by Chandana. Great. Then, now, very interesting question. Reasons for a witness to turn hostile. U-turn witness. What are the causes? Option A, threat of fear. Option B, personal gain like bribery. Love affair. It is given in standard textbook. Love affair. In some cases I noticed love affair. love affair भी हो सकता है ना? Then jealousy, delayed prolonged trial, all the above. All the above. How many of you agree with love affair? Yes or no? So in criminal cases especially, the case runs for many years, 1 year, 2 year, 3 year, like that. So you'll become very close to everyone, including clerk, including advocates. You'll also become advocate. Huh? So my guy, see, now we forensic expert, so we are going to court every month, almost every month, every 15 days once. So we are more of advocates, less of doctors basically. How many of you agree with me? Okay, first hand knowledge. Okay, no problem. Sutapa will at the end, because we are almost, it is 8:45. I need to complete in 5 minutes. Okay. How many of you agree with this? Acha, different. Okay, Mohammed is telling yes, sir. And Masoon also telling yes, 100% agreed. Okay. So good, and don't ask me about my experience. Okay. So I don't have any experience like that. But you'll become very close to everyone. So the court, I know, the difficult thing to, you should have a lot of patience. Sometime you need to wait 1 hour, half an hour, 2 hours, like that. Sometime up to 6 o'clock, 7 o'clock. So it really really need something, Huh? So don't worry, Snehajit, that's okay. Hello. Next. Which of the following is leading question? Achha, this is very good question. When he saw the body, what was the weapon used in the murder? What was the length of the knife? Was the length of the knife is 10 centimeter? So this is a very interesting question. Like this, they will hold like this in court. They'll ask, is this the weapon used? Yes, sir. Is this the length is 10 centimeter? Yes, sir. What was the weapon used? Sir, knife, sir. So question is very simple. The answer is D. D. Good. I hope you total length, that is great. So many answered. So I'm not going to discuss about it. Simple one. Which statement is right? Which statement is correct? Child below 12 years of age not required to take oath. A person with mental illness and intoxication cannot testify in the court of law. Dumb witness can also testify in writing. What is this? Very interesting question. Dumb witness can also testify in writing. Like this, writing. Dumb witness. Try. So the answer is all the above. Answer is all the above. Many answered correctly. 7, I think Snehajit answered. Sneha, Mohammed and Srinivas. Sneha, good. Mohammed and by Tota. So great, Tota. Great. Now this is one more interesting question. You just go through this. Already we discussed. Try to answer. Meanwhile, I'll have some water. So many answered correctly. Higher court will be given preference. The answer is C. The one you receive first will be given preference irrespective of the type of court and case. False. So I said 3 rules. Rule 1, rule 2, rule 3. So first rule 1, then rule 2, then rule 3. But here it is 3 rule, that is third rule, that is false. Criminal cases will be given preference irrespective of date of receiving summons and type of court. False. IPCs under which case filed will be used to decide preference. False. So all the 3 false. The correct answer is C. Correct answer is C. This is how you should answer. Good. Many answered. That's great. This is 8. Then 9. Leading questions are allowed in. Leading questions are allowed in cross-examination, chief examination, when it is hostile witness, if the court permits, all the above. Okay. So Raja is first to answer. Raja. So Raja said all the above. So all the above. Simple one. True about examination chief. Try this. First examination of a witness in the court of law. True. Witness is examined by a lawyer of that who has called him. That is also true. Leading question must not be asked. True. All are true. Answer is D. So now all of you just tell me your score. Your score, guys. So what is your score? You analyze by yourself. So you let me know what is your score. Okay, Snehajit got 9. Mohammad Ansari got 10. Tota got 8. Marsudan got 10. Rudai got 10 out of 10. So anything more than 5 is great. I consider anything more than 5 great. So you are great. You are great. Good. So this is about the legal procedure. This completes legal procedure. So next class, so we are going to start medical law and ethics. Medical law and ethics in 1 or 2 classes. This completes your legal procedure. After this, you just go through these notes. No need of any other textbook. If you want to buy, you can buy. But classroom notes, if you revise, that is more than sufficient. For time being, I'm telling you. Okay, more than sufficient. So refer any one source, not too many sources. I know, too many sources. One source, any one source properly. So that is enough for forensic medicine. Forensic medicine is a major subject. Guys, it's a major subject. It's one of the very important subject. As a doctor, you must have legal knowledge. Nowadays, there are so many legal cases against the doctor. Legal knowledge is very important. Only subject which can teach you the legal knowledge in medicine, that is forensic medicine. Yes or no, guys? Yes or no? So only subject which can teach you the legal system. Other 18 subjects, they will teach you medical knowledge, how to treat, how to save the patient and all. We forensic medicine people, we do teach you how to save yourself, how to protect you from the cases, how to be a good doctor, what we can say, very knowledgeable doctor, strong doctor. You know, knowledge is power. Your knowledge is your power, nothing else. So I asked many times myself, what is power in life? So I came to know the power is nothing but vitamin, not the vitamin M. It is not the influence. It is not the anything. It is the knowledge. Your knowledge is your power. So when you have knowledge, people do wait for you. You will become very strong. Agree with me, all of you? Knowledge is equal to power. Yes, Mohammed Ansar is telling, sir, lawsuits are very common. Hundreds of cases. Not hundreds, I'm telling you, thousands of cases nowadays. Not easy. Not easy. But you can avoid some cases when you have good forensic knowledge. So I request everyone to change your mindset. Change your mindset about the forensic medicine. Forensic medicine is a big subject. 100-mark paper in university exam, 100-mark, and very important subject in entrance exam. And this is the subject will give you legal knowledge and very interesting. And this booth bungalow series, forensic mystery series, very interesting. So maja aayega, hai na? So I hope you are understanding. Snehaji Chaudhary. So I request everyone to read forensic at least 2 hours every week. At least 2 hours every week. Not every day, 2 hours every week. Make notes, attend some classes. Done. No problem. Okay? Yes, guys. Okay. Yes, guys. Am I speed is okay? I'm very fast, very slow, or very boring one way. So just give me suggestion because you are Gen Z, Gen Z students. We are old. Okay, so we should have some feedback from you. Okay, it's okay. Rajesh is telling, sir, perfect, very compatible, adequate pace, perfect. First hand knowledge, beta. First hand knowledge means eye, perceived by ear. हमने देखा, हमने सुना, हमने देखा, हमने सुना. All this basically first hand knowledge. Ipshita is telling, sir, wonderful session. You are a great teacher. Okay, great Gen Z teacher. Okay, that is what feedback I wanted. Gen Z guys, you know. So I hope after talking to you every day, I will also become Gen Z guy like you, 20 years less than my actual age, you know, 20 plus. Good. So that's it about the today's session, guys. So thank you all. So thank you. We'll see you in Faray series in next class. And work hard, study well. I said knowledge is power. Thank you all. Thank you.